Hello viewers, in this lesson we will learn about the bank guarantees. Objectives: to learn about the concept and modus operandi of bank guarantees, to learn about the law on bank guarantees, to learn about the rulings of higher courts on bank guarantees. Viewers, now we will learn about the concept and modus operandi of bank guarantees. Concept: bank guarantees are contracts and they are also termed as contracts of guarantee. A contract of guarantee is a contract to perform the promises or discharge the liability of a third person in case of a default. It could be for repayment of a debt or performance of a promise. A contract of bank guarantee is a kind of guarantee wherein the bank promises to repay the liabilities of the debtor in case of his default or pay the agreed amount in case of non-fulfillment of contractual obligations pertaining to the performance to third parties. By furnishing a bank guarantee, the customer of the bank, for identification purpose, he is called as debtor, can acquire goods, buy equipment, draw loans, and expand his business activity. A bank guarantee is a written document executed by the intending parties to secure compliance with the contract. It involves three parties as it is very much a contract of guarantee. As for instance, A contractor agrees to construct a building for B, the employer. Both of them entered into a written agreement. As a part of the agreement, A agrees to complete the construction in a period of 9 months, and he also furnishes as a security for the performance of the contract a bank guarantee for rupees 10 lakhs. The contract of bank guarantee is entered into by the agreed banker and the contractor, that is A and the bank, which furnishes a guarantee bond in favor of the employer B. In the event of any default committed by A, as per the terms of the contract of guarantee, B can encash the guarantee by invoking the contract without having to undergo any hassles of litigation in a court of law. The bank has to pay the guaranteed amount without any demur on invocation of the contract. Between the bank and A, there will be a separate contract for the bank to enter into this contract of bank guarantee, as A has to furnish proper security to the bank for the bank to furnish a guarantee bond in favor of the employer B. Thus, the contract of bank guarantee is a tripartite contract. The bank guarantee cannot be revoked at the whims and fancies of the contractor. In case of the necessity of furnishing security deposits, in lieu of depositing money, the bank guarantees can be furnished in various construction and supply contracts. A bank guarantee is defined as an unconditional written undertaking furnished by a bank on behalf of its customer to a third party to ensure performance of a contract or any lawful discharge of an obligation between its customer and the third party. The guaranteed sum shall be paid by the banker to the third party on invocation of the bank guarantee without any demur. The bank guarantee can be invoked for non-performance or even bad performance of contractual obligations. Bank guarantee is a great security for ensuring contractual obligations and protecting the interest of the promisees in performance of a contract. By issuing a bank guarantee, the bank takes the responsibility of paying the guaranteed amount to the third party on its invocation. For issuing this guarantee, the bank gets some commission from the customer on whose behalf the guarantee bond has been issued. The bank guarantees are generally issued for commercial purpose, but even in individual cases, for protection of the promisee in a contract, the bank guarantee can be demanded. Further, in litigation in courts of law, the courts may direct the furnishing of bank guarantees as a measure of security to one of the litigants. Advantages. 1. By this practice of bank guarantees, conducting the transactions in domestic as well as international trade, business, commerce, and industry becomes smooth and secure. 2. The bank guarantees reduce the financial risk of the contracting parties. 3. The bank guarantees can open up new markets. 4. They can improve project sustainability. 5. They facilitate privatization of enterprises. 6. They also facilitate public and private sector partnerships. 7. They provide access to capital markets and also commercial banks. 8. They may facilitate increase of the rate of private financing for several key sectors of business, especially the construction activity. 9. They facilitate increase of banking business as the banks get high commission for furnishing the bank guarantee bonds. Modus operandi. The bank guarantees are furnished by the banks on request of its customers to the directed party by way of furnishing a guarantee bond, undertaking to pay the agreed sum of money on invocation of the bond to the said party without any demur. In practice, the banks may issue different types of bank guarantees. Some of them are discussed here. 1. Performance guarantees. This type of guarantee is very much used globally for securing the completion of the contractual responsibilities on construction works or delivery of goods, whether on procurement or manufacturing, and they act as security of penalty payment by the promisor for non-performance or bad performance or delay in performance of the contractual obligations. Normally, the contract speaks of levy of penalty by way of liquidated damages for delay in performance, which could be secured by the bank guarantees. 2. Service bank guarantees. In crucial jobs involving finance and money, like the job of a cashier, manager of a bank, instead of depositing money as security, a bank guarantee for an agreed amount can be furnished by the employee to the employer, and in case of any financial exigency like embezzlement of cash, the guarantee can be invoked. 3. Direct bank guarantees. This type of bank guarantees are issued by the bank directly to the beneficiary without concerning any correspondent bank. This type is less expensive and is also subject to the law of the country in which the guarantee is issued, unless otherwise it is mentioned in the guarantee document. 4. Indirect guarantee. In this type of guarantee, a second bank is involved on the demand of the beneficiary. However, this type is more expensive and time consuming. 5. Tender bond guarantee. This type of guarantee is issued in support of a tender in domestic and international trade. It provides a financial remedy to the beneficiary in the event of any breach of the contractual terms. Advance payment guarantees. This type is used where the promisee calls for depositing a sum of money at an early stage of the contract so that he can recover the amount deposited in advance in the event of any breach of the covenants of the agreement. The bank guarantee is furnished in lieu of the depositing of money. Likewise, several other types of guarantees like payment guarantees, loan repayment guarantees, rental guarantees, credit card guarantees, fidelity guarantees, and like ones are issued by banks in practice. The concept, law, and the modus operandi, legal liability of the parties are ultimately same for all types of bank guarantees. Viewers, we will now learn about the law on bank guarantees. The law governing the bank guarantees is basically the Indian Contract Act 1872, apart from the Reserve Bank of India regulations and guidelines for sanctioning and invocation of bank guarantee. Sections 126 to 147 contain the relevant provisions on the law of guarantee, and they apply alike to the bank guarantees also. Section 126 of the Indian Contract Act defines a contract of guarantee as a contract to perform the promise or discharge the liability of a third person in case of his default. The person who gives the guarantee is called the surety. The person in respect of whose default the guarantee is given is called the principal debtor, and the person to whom the guarantee is given is called the creditor. A guarantee may be either oral or written. Even though under this section, a contract of guarantee can be oral, a contract of bank guarantee must be invariably in written form. Further, a contract of guarantee is a contingent contract as defined under Section 31 of the Indian Contract Act, as the contract of guarantee is invoked on the arising of situations like non-performance, bad performance, or breach of contract or like issues. Hence, Sections 31 to 36 relating to the contingent contracts also apply for a contract of guarantee. In addition, the bankers must follow the regulations, guidelines issued by the Reserve Bank of India from time to time relating to sanction and invocation of bank guarantees. Features of bank guarantees. 1. Existence of a recoverable principal debt. The contract of guarantee depends upon the existence of a recoverable debt. The House of Lords in Swan versus Bank of Scotland, 1836, where the payment of the overdrafts of a banker's customer was guaranteed by the Bank of Scotland, and it was later found that the overdrafts were contrary to a statute, held that the bank was not liable and observed that if there is nothing due, no balance, the obligation to make that nothing good amounts itself to nothing. That means there was no principal recoverable debt. As an exception to this rule, in Garrett versus James, the Chancery Division, 1925, held that a guarantee even for a void debt was enforceable against the directors of a company if they guaranteed their company's loan, which was found to be void, as being ultra vires. 2. Tripartite contract. According to Section 126 of the Indian Contract Act, a contract of guarantee is a tripartite contract. 3. Consideration. Under Section 127 of the Indian Contract Act, whatever is done for the benefit of the principal debtor is the consideration in the contract of guarantee. 4. Contract of oberma fide. The contract of guarantee is not a contract of oberma fide, that is, a contract which requires full disclosure of all material facts by the parties, unlike the contract of insurance. However, Sections 142 and 143 of the Indian Contract Act provide exceptions to this rule that a contract of guarantee obtained by misrepresentation and or concealment is invalid. 5. Modus of the bank guarantees. Bank guarantees must be in written form only. Further, Necessary stamp duty also must be paid as per the Indian Stamp Act 1899, read with the appropriate notifications of the state government concerned. 6. Extent of liability of the surety. Under Section 128 of the Indian Contract Act, the liability of the surety is coextensive with the liability of the principal debtor unless it is otherwise provided under the contract. In case of bank guarantees, the amount is fixed in the guarantee bond and the bank is liable to pay the stipulated sum on the invocation of the bank guarantee. 7. Application of the essential requisites of a contract. For a contract of bank guarantee, all the essential requisites of a valid contract as contemplated under Section 10 of the Indian Contract Act are invariably applicable. Kinds of bank guarantee. A contract of guarantee can be a specific guarantee or a continuing guarantee. A specific guarantee is one which is applicable for a particular transaction. A continuing guarantee is one which extends to a series of transactions as provided under Section 129 of the Indian Contract Act. In banking practice, mostly bank guarantees are issued as specific guarantees only. Revocation of bank guarantees. A specific guarantee cannot be revoked under any circumstances, but it can be intercepted under certain circumstances so that the guarantor is discharged from the liability. In case of any fraud or misrepresentation and concealment of information as provided under Sections 142 and 143 of the Indian Contract Act, the contract of guarantee becomes invalid and the banker can refuse payment on the invocation of the bank guarantee. However, under Section 139, a continuing guarantee may at any time be revoked by the surety as to future transactions by notice to the creditor. So the bank can invoke this Section 139 for revoking a continuing bank guarantee. Modes of discharge of surety from liability. A surety is also termed as a favored debtor, as the creditor beneficiary can directly sue the surety. This is because once a contract of guarantee is signed, the surety cannot go back on his obligations. A contract of specific guarantee cannot be revoked on the whims and fancies of the surety, but the continuing guarantee can be revoked as against future transactions. However, there are certain special circumstances under which the surety can be discharged from the liability. Thus, though the contract of guarantee in principle cannot be rescinded, it can be intercepted and the surety can seek himself to be discharged from the liability so that no more he can be termed as a favored debtor. The circumstances under which the surety can be discharged are narrated hereunder. 1. By the surety in case of continuing guarantee. As stated before, under Section 130 of the Indian Contract Act, the surety can revoke by notice a continuing guarantee in respect of future transactions. 2. By the death of surety. Under Section 131 of the Indian Contract Act, the death of the surety operates in the absence of any contract to the contrary as a revocation of a continuing guarantee so far as regards future transactions. 3. By novation. Under Section 62 of the Indian Contract Act, by novation, that is, substitution of a new contract for the existing one, the surety is discharged from the liability under the existing contract. 4. By variance in the terms of the contract. Under Section 133 of the Indian Contract Act, the surety is discharged from the liability if the contractual terms are varied by the creditor and the principal debtor without the consent of the surety. 5. Release or discharge of the principal debtor. Under Section 134 of the Indian Contract Act, release or discharge of the principal debtor by the creditor eventually discharges the surety from the liability. 6. Compounding by the creditor. Under Section 135 of the Indian Contract Act, where a creditor without the consent of the surety compounds with or gives time to the principal debtor for repayment of the debt, the surety is discharged from the liability. 7. Creditors' acts and omissions. Under Section 139 of the Indian Contract Act, creditors' acts and omissions impairing the surety's eventual remedy would discharge the surety from the liability. The Supreme Court, in the case of Amritlal Govardhanlal versus State Bank of Travancore and State of MP versus Kaluram, analyzed well this issue. 8. Loss of securities. Any loss of security occurred due to the negligence or act or omission on the part of the creditor releases the surety from liability either in full or in part, but limited to the securities existing at the time of the formation of the contract. 9. Invalidation of the contract. Under Sections 142 and 143 of the Indian Contract Act, any guarantee obtained by misrepresentation or by concealment of material circumstances is invalid. Rights of surety. The rights of surety, as provided under the Indian Contract Act, apply alike to the banks on bank guarantees also. As for example, the bank is entitled for exercising the right of subrogation under Section 140, right to take over all the securities under Section 141, right to refuse payment under the context of invalidation of the contract under Sections 142 and 143, and right to indemnity under Section 145 of the Indian Contract Act. Viewers, now we will learn about the rulings of higher courts on bank guarantees. Basically, bank guarantees are invocable without any demur on the part of the bankers, that is, the sureties. However, there are circumstances which were approved by the higher courts to restrain the invocation. Where there is fraud, misrepresentation, concealment of material information, forgery, and like issues, the courts can interfere and restrain the invocation of bank guarantees. The Supreme Court and various high courts laid certain judicial precedents by the doctrine of stare decisis. Those decisions are discussed here. 1. In Maharashtra State Electricity Board versus Official Liquidator, Ernakulam, the Supreme Court held that the courts must exercise caution in restraining the invocation of bank guarantees, as the credibility, respectability, reliability of the assured mode of payment through bank is necessary for the growth and promotion of trade, and the faith of people in bank should not be affected. 2. In UP Cooperative Federation Limited versus Singh Consultants and Engineers Private Limited, the Supreme Court observed that the commitments of banks must be honored free from interference by the courts, and only in case of fraud or any case where irretrievable injustice would be done if bank guarantee is allowed to be encashed, the court should interfere. 3. In ITC Limited versus Debt Recovery Appellate Tribunal, the Supreme Court held that the bank can refuse payment in case of clear fraud and the bank's knowledge as to such fraud. 4. In Hindustan Construction Company Limited versus State of Bihar and others, the Supreme Court held that a bank guarantee is an independent and distinct contract between the bank and the beneficiary, and both the parties would be bound by the terms thereof, and as such, the invocation will have to be in accordance with the terms of the bank guarantee, or else the invocation itself would be bad, and the bank, under such circumstances, was under no obligation to pay the amount. 5. In National Highway Authority of India versus Messrs. Ganga Enterprises and another, the Supreme Court held that a contract of guarantee is a complete and separate contract by itself, and the courts must not interfere with its enforcement unless the enforcement is against the terms of the guarantee or if there is any fraud. 6. In Winitech Electronics Private Limited versus HCL Infosystems Limited, the Supreme Court held that the invocation of a bank guarantee can be stalled by the courts in case of any fraud. Thus, under normal circumstances, the banks cannot refuse payment on invocation of bank guarantees, nor the courts can interfere in restraining their invocation. Well, viewers, I hope you have enjoyed the session. We will meet again. Thank you.